Hello, everyone, and good morning, good afternoon, good evening, and welcome. Welcome to and thanks for joining us for today's global webinar on law enforcement access to data cross borders, strategies to manage risk and protect your organization. My name is Gian Giolivi. I'm a partner at Dentons Milan office and I lead the European intellectual property data and technology practice. And I'm a member of Dentons global cybersecurity team. And I'm very, very pleased to be joined today by two of our fantastic partners and colleagues from Dentons Global Network. So we have Chantal Bernier, who is the co-chair of Dentons Global Privacy and Cybersecurity Group and a member of the firm's Canadian Privacy and Cybersecurity Practice. By the way, I'm reading just to name properly all your titles. You got a lot of titles, Chantal and Todd. And Todd Daubert, he's a partner of our in Dentons Washington, D.C. office and serves as global chair of the firm's communication and technology sectors, global lead of the technology, media, and telecommunications sector, and US privacy and cybersecurity team lead. By the way, do you want to be something else, Todd? Because, otherwise, but most of all, we're all part of the same team. So together we are part of Dentons Global Privacy and Cybersecurity Group, co-chaired by our fantastic Chantal Bernier. So I think with that, we can get started. So we've got an issue at the moment. Everyone is talking about digital sovereignty, and but also in Europe. And I'm very happy to have the honor of moderating this conversation with on the other side of the Atlantic with Canada and the US, because this is really a very important issue also from a European perspective. Actually, if I were to give a European introduction about this issue, what we're seeing, yes, there's a push from industry and governments to promise protection from foreign access, particularly in this current wonderful geopolitical moment. And service agreements tend to increasingly require data residency, particularly in Europe, but then we will ask from Chantal and Todd whether that's the case also elsewhere. Regulation are increasingly restricting cross-border or mandating local storage. So, and at the same time, extraterritorial reach is growing. And by the way, in Europe, this also affects data transfers. So, in the sense that the European and US data privacy framework cleared its first hurdle in the European Tribunal, but now is subject to a closer scrutiny with the European Court of Justice. And actually, we're all expecting a sort of Schrems 3 moment where actually it will be once again challenged and we will have to restart all over again. So the FISA section 702, and perhaps Todd, you will tell us about that, still allows bulk access, and the framework is now politically more fragile. I'm trying to be as diplomatic as possible, Todd. And, also with the removal of the democratic members, which has put in doubt certain oversight pillars of the adequacy finding from a European Commission perspective. I'm talking about the previous Privacy and Civil Liberties Oversight Board. From a European perspective, the center of gravity is shifting from purely contractual comfort, i.e. SEC plus TIA, transferring impact assessments, to architectures that remove the risks at source. So moving to bring your own key, to hold your own keys, and actually moving to protecting data, not just at rest and in transit, but also in use, and using new privacy enhancing technologies. So there's an increased concern, actually something that happened in Canada. So if we move to the next slide, because normally we started to be worried about what was going on in various jurisdictions, but normally Canada tend to be a sort of, from our perspective, a quieter jurisdiction. But actually there's been a production order that subscriber and account data stored outside Canada, and with a request that they can engage jurisdiction, disclosure, transfer, and blocking laws. And so there's been a lot of commentaries. And by the way, there's very, very nice article about it from Chantal and Todd. And you'll have the link afterwards. And what's the point? Because that raised the debate once again. Chantal, if you can actually start and actually let us know what the law is about.
Yes, certainly. Thank you, Janji. And indeed, I think it is worthwhile sharing with the participants that the three of us decided to hold this webinar precisely because our clients were asking for clarification. And you shared with us how this decision from kind, polite Canadians has really sent shockwaves through Europe. And I'm referring to the King versus OVH group. A decision of the Ontario Court of Justice, but first it needs to be put in context of public international law. There are really two main legal doctrines in international jurisdiction. Some states, for example, the UK, US, Australia, have adopted the doctrine of presumption against extraterritoriality, meaning if their legislation, the Act, does not expressly provide for extraterritorial application, it doesn't. Other states, like the EU, as a group of states, and Canada, jurisdiction is based on territorial nexus, meaning that as soon as there is a real and substantive link between the matter and the country assumes jurisdiction. Its laws apply to it, and its tribunals have jurisdiction. So if we go to the next slide, I'm going to give you a little bit of what happened in King versus OVH group. And the court decision is on appeal, but I must share with you that it is a very solid decision. So I'm not going to be so intrepid to make forecast about the appeal outcome, but it is a very solid decision. It is based on public international law. And essentially what happened is that the court allowed a production order under the criminal code for the Royal Canadian Mounted Police, the RCMP, against a company, OVH Hébergement, which we will call OVH Canada, which is an affiliate of the parent company in France, which is OVH Group. So for the purpose of the discussion, just to make it easier, we'll refer to OVH France and OVH Canada. So what happened there is that the production order was issued and served to OVH Canada. And that requested access to data stored abroad in France, in the UK, in Australia, because that's where OVH France, the parent, holds data. It was contested in court. That is how we have this decision. And the court allowed the production order on these important points. The first one, it said, OVH France has an affiliate in Canada. Therefore, there is a real and substantive link. Secondly, the production order is served upon OVH Canada, a Canadian company which is compellable under Canadian law. And this is important to remember, considering what Todd will talk to us about later on technological safeguards, is that the court said the affiliate in Canada has technological access to the data stored in France. Therefore, it has possession and control, or it certainly has control, and therefore is not only legally obliged to produce the data, but actually is capable of doing it and therefore must produce it. And this is aligning with actually law reform in the House of Commons in the form of Bill C-22, which we have on the next slide, where the bill seeks to, in fact, enshrine in law this expansion, if you will, of extraterritorial access by Canadian courts to foreign held data. I will leave it at that in the interest of time. But what we see, as you were saying right at the beginning, Janji, is that we see international cooperation taking the form of expanded extraterritorial lawful access.
So I would say there's some slight concern. There's a solid decision and solid legislation, but let's move to Todd about the US. What about the Cloud Act? The Cloud Act, and what about the solid decisions in the US?
Yes, so I'm resisting the temptation to go for humor and to tell everyone how you've been begging me for a selfie, Gianji, but
Yes.
I thought I'd start with a few sort of misunderstandings about the Stored Communications Act, which is the act that the Cloud Act modifies. And I think that for a lot of jurisdictions outside of the US, there's a perception that these statutes are ways to get the US more control over extraterritorial data or to gather or to empower the US government. But actually, it's the opposite. It was actually adopted to create boundaries around what the government could ask for and what it can't ask for, and to create protections for primarily US citizens. And so when the Stored Communications Act came along, the act was silent with respect to extraterritorial reach. And just as Chantal described, in the US, when a statute doesn't clearly say it applies on an extraterritorial basis, there's a presumption that it doesn't. So there was a challenge many years ago at this point, where the government had requested information from Microsoft, and the information was stored on their servers in Ireland. And Microsoft won the appeal. The Court of Appeals said, well, no, because the Stored Communications Act does not apply extraterritorially because it doesn't say that it does. So the government appealed that to the Supreme Court. And while the appeal was pending, Congress passed the US Cloud Act. And the US Cloud Act changed the framework pursuant to which the Stored Communications Act is applied. And it basically took location out of the equation. And it's really about whether you, if the US government has jurisdiction over you, then the SCA process applies if you have control over the data being requested. That was the big change. And there's protections. The process that they have to follow in order to get the information changes based on whether you're asking for the content of messages versus the existence, the metadata, whether you are asking for public-facing services or whether it's for employees. And so there's a lot of questions that you can get into as to when you have to produce information under the Stored Communications Act. But I think it's really important to see that what the issues that Canada are addressing now are very similar to the issues that we addressed here. And I think that when you think about it from sort of an analogy basis, it's as if you lived in a town that was on the border of two jurisdictions. And, you know, I used to live in Konstanz am Bodensee in Germany. Half the town is in Germany, half the town is in Switzerland. And so it would be as if I'm a German resident and the German government said, well, give me this information that's in your possession. And I simply put it over the border and said, well, no, it's in Switzerland. You can't have it. Now, in the age of technology, most people realize that it's less the location and it's more about the ability to control and direct what happens. And I think that the issues that you're seeing that we addressed in the US with the Cloud Act and what Canada is addressing now are really about this realization that in the age of technology, this location of the stored data may be less important than the ability to control it and to access it. So, yeah, and I guess this goes back to what I covered, where the Cloud Act addressed that Microsoft decision with Ireland, and so now, if you're a covered provider by the Stored Communications Act, then what matters is, do you have control over the information? And that's really the main issue that I was trying to point out with this. So if we could move forward. And so, what's interesting is in the age of technology, for all the reasons we were just discussing, you can have two laws of two jurisdictions that are fundamentally opposing each other. And so we often have clients who need to weigh out how you address this. It's not necessarily an inconsistency. There are usually pathways to determine how to protect your interests and how to demonstrate that you're not violating one jurisdiction's laws because you are complying with another. But we're fortunate today because we happen to have an expert here as a moderator, Jianji, who can add a little bit of color around to GDPR's Article 48 and how, when you face yourself with a request from Canada or the US, how GDPR Article 48 plays in and how we can think about this challenge.
Thanks. Thank you very much. And by the way, thanks for raising a question to the, to the moderator. And also, it's I've got Article 48 in front of me, so I've got a big advantage now to respond to your question. But it's very interesting because also, so we are seeing technologies that are increasingly rely upon data exchanges, and it's international data exchanges. And actually, you were saying data can be elsewhere, but sometimes you may not know where they are because they move actually very quickly in certain instances, and increasing effect of regulations and increasing amount of regulations with extraterritorial effect. And we just heard that from Chantal and from Todd, from two very important jurisdictions. And what about Europe? A third country order, as you can see from the slide, it's not automatically recognized as enforceable in the EU. And here I'm reading the Article 48. Under Article 48, any judgment of a court or tribunal on any decision of an administrative authority of a third country requiring a controller or processor to transfer or disclose personal data may only be recognized or enforceable in any manner if based on an international agreement, such as a mutual assistance treaty enforced between the requesting third country and the union or a member state, without prejudice to other grounds for transfer under this chapter. And I'm referring to Chapter 5 of GDPR. What does this mean? There's two scenarios. One, if there is an agreement, then obviously you would have to look at the agreement and check whether there's a dedicated government-to-government channel. And then in such case, it would be up to the government to transfer the data. If there is, so you would have to refer to the relevant authority. If you are required, so there's no such channel, and you still decide to provide the information, the data, you would have to follow a two-step test, which is, first of all, identify legal basis for disclosure. So look at Article 6 of GDPR. Without a proper legal basis, the transfer is unlawful. So you may not always be obliged to transfer this data. That's the key message. And also at the test, whether actually the request is within the perimeter of the international agreement. We did found in the past sometimes a tendency not to have a clear idea about what is the, whether the actual request fall within the agreement. And then even in such case, if there is no agreement, that means that the request is not enforceable. You can still transfer the data, but once again, you would have to double check what is the legal basis for transferring this data, for instance, under a legitimate interest under Article 6 of F of GDPR, which will also be subject to a balancing test, and also use a transfer tool, i.e., which could be assess whether there's an adequacy decision or if there's a derogation under Article 49. But as a key message to convey, the foreign order alone is not a sufficient transfer. And what we are seeing in terms of trend is that geopolitical blocks from a regulatory perspective, at least in Europe, are trying to show their muscles. So also from a security perspective and data access perspective, we will be seeing a lot more defenses in this respect. So
yeah,
you go,
and
Tom.
to add into what Gianji is saying here, I think that what this really highlights is the importance of thinking through these issues in advance. Because if you've thought through in advance what your structure is for controlling data, where you're storing it, why you're storing it in a location, the conditions pursuant to which you would normally transfer it during everyday business, and your legal basis for these transfers, you will find yourself in a much better position if and when you do get a request for information from any of these jurisdictions. And because even if your story would be exactly the same, if you've documented all of your decisions contemporaneously, then when you need to produce those documents, you're less likely to be challenged by a requesting authority as just providing a post hoc rationalization. And you'll find yourself in a much better position. And then if you've also done this, this can become a competitive advantage for you in the marketplace, because you can explain how you set up your systems, what your goals are, how you respond to people, and these ways of communicating your professionalism, your decisions, your framework can not only, get you a competitive advantage, it can also be a signal to regulators that you're not the party that they should even bother sending the request to in the first place. And I think that, when you look at the Stored Communications Act as amended by the Cloud Act, what you'll see is 9 times out of 10, that request is going to go to the underlying telecom carrier or broadband service carrier. It's not going to go to the company that's using that service, because you might not even be covered by the ability to be mandated to provide the information. So I think that of course, an attorney would say this, but take some time early to plan ahead and to document these decisions, because all of these situations you could find yourself in, if you've done this in advance, all of the facts that Gianji was talking about, you can already have that solved, and then the answers to your question when you're asked them.
Thanks, Todd. And I think this is a very good point, but still remaining with you, if we can move to the next slide, because our clients are asking the ways to protect their data. And, you're also an engineer. No one is perfect. I'm just kidding. But it's you being an engineer as well, so you can also address certain protection measures for the data, also from a technological perspective, but also from an organizational point of view. So from a strategy perspective, what to do?
Yes, so I think that really what's very important when you think about how technology plays a role in these answers, governments can't compel you to provide information you genuinely don't have any control over or access to. So that leads to the question of how do your choices around use of technology impact your ability or your obligation to produce information? And I think that, again, to the point of location matters less. If you say you're a US company or a foreign company that has operations in the US, and you get a request for information, one of the first questions that you have to ask is, do I have access to this information? If the information, even if it's stored in the US, if you don't have any access to it because it's encrypted, and the key for encryption is controlled by a third party, well, then you don't have to produce that information. So one way of looking at your technological stack is my information encrypted? And who has the right to control the keys to encryption, right? But that's not sufficient, because if you have a contractual control over that, so that the other party who actually holds the keys to encryption, you can order them under your contract to release information, it doesn't help you. The fact that it's encrypted and that someone else has the key isn't dispositive when it comes to producing information. So you have to put together the technology with the contractual rights to determine whether you actually, as a matter of fact, have access. Another way that you could handle this is you could set it up so that information is held by a third party, and you could set your entity up as a service provider to that third party with respect to the data, so that you only get access to the data for the short period of time that you need to provide the services to the other party. And then you delete the information, because if you don't have persistent access to the information, and it's actually the other party's the controller, well, then if you get a request for the information, you neither have technological access to it, you don't have it stored on your systems, and you don't have the contractual right to make a decision whether to disclose it or not. So I think that the key point for technology is, do you have real-time access to it? Do you have persistent storage of it? Is it encrypted? And do you have the right to have it unencrypted? And those are really far more important than necessarily the location of the data. Although, if the third party has the data located within your jurisdiction, then it makes it more likely that that third party could be compelled to provide the information.
Thanks, Todd.
So, yeah.
Go ahead. I think we can move to the next slide also with regards to independent control.
Yeah. So when you put all of this together and you start thinking about, if your goal was to limit access to information that would be subject to production to US authorities, well, then you'd have to put all of those factors together. And for the entity that controls the data, to the extent that you can make that entity not subject to US jurisdiction, well, then you've already prevented the information from being produced, because the US government has to have jurisdiction over the entity that it's asking the data from in order to put forward a valid request. And so the entity that holds the data, to the extent you have no US offices, you have no agents for service, so that you're not located within the US, that you're not targeting the US with marketing. So that entity that holds the data isn't doing business with the US and targeting for marketing, that it doesn't have common US affiliates or US ownership. And what that gets to is, it's less of a question of corporate form, but more that idea that, okay, even if you have no US offices, even if you have no agents of service, even if you have no marketing for that entity, if you've got an agreement at the corporate level where the other entity who is under the jurisdiction has control to direct you to do things, well, then it doesn't matter. You're still covered. So you'd have to have no US ownership or affiliates, and you have to have no US provider that has the right to access the data or to get control of the data. So, we have a lot of clients who look very carefully at their corporate structure, and they choose to put all of their data into sort of a data corporation. And they might choose the location of that data corporation and the purposes that it serves very carefully in jurisdictions based on its business, and then set up the relationship between the data corp and all of the other affiliates with these types of issues in mind, so that when requests for data come in, or when they're out marketing to their customers and to their business partners, the steps they've taken to protect the data, they'll have solid documentable responses. Because the last thing that we or anybody else would advocate is trying to be too cute with a government that's requesting information from you and, you know, acting like you don't have control, when in fact, if they dug into it a little bit more closely, you do have control.
Thanks, Todd. I think this is super interesting. So a lot will change, and we will be seeing also a lot of tech measures as well, like secure multi-party computation and so forth. But setting aside, that part, but looking at the risk mitigation, and I think, Chantal, you've been a regulator, so you're best placed at addressing risk also from a governance perspective. So what would you suggest doing? What are the tools also from a governance perspective?
Yeah. By way of an introduction, first of all, yes, as a former regulator, I know the importance of governance to demonstrate accountability to regulators. And that is a huge asset in terms of your relationship with the regulators. So that's number one. Governance is your first line of defense. Secondly, I'd like to tie this part to a critical point that Todd just made, which is that technological developments have shifted the law from being based on location of data to control of data. Hence, the increased importance of the governance structures. And the third point I'd like to link it to is a point that you've made, Janji. When you spoke about Article 48, you showed the tensions that are occurring in the sense that you have companies who want to withhold the data, and you have states who are pulling to access the data. So I believe we must approach this topic understanding that data sovereignty, if we want to call it that way, is more aspirational than real. And if, as I was listening to Todd's conditions, this is what you could do to shield yourself from the US Act. Well, I'm sure that a lot of the participants were listening and thinking, well, we can't do that. That's no way to function. So now we're moving to, okay, get over it. There will be extraterritorial reach. You may, with exceptional circumstances, be able to shield yourself, but start from the point that the law is shifting. And so the first tool that I'm particularly fond of, that I'm particularly impressed with, is transfer impact assessments. It's a broadening legal obligations. We've seen it as a result of the Schrems II decision, where the Court of the European Union said, well, countries should not just have standard contractual clauses, they should assess whether the country to which they send the data is actually reliable, so to speak, is actually adequate in terms of protection. The Quebec Act respecting the protection of personal information in the private sector was amended to make transfer impact assessments a legal requirement to communicate data outside Quebec. And going back to another bill that has just been introduced in the House of Commons in Canada, the Protecting Privacy and Consumer Data Act is actually introducing an obligation to proceed to transfer impact assessments before you communicate data abroad. And this really goes to the point that Todd was making a moment ago, is that when you document your risk assessment of transferring data, as well as the mitigation measures that you have identified and applied, you are building a demonstration of due diligence in protecting data in the context of extraterritorial reach. If we go to the second one, another governance measure is to really make sure you are in legal control. And again, this goes to Todd's point. So how do you stay in legal control? Well, you transfer the data outside. You have no choice. You're a global company. Either you have service providers outside of your country, or you have affiliates, as was the case of OVH in another company. So you need to at least rein it in, meaning to have data protection clauses in the service agreements or in the intergroup agreements, where, for example, you ensure that the service provider or your affiliate always submits lawful access requests to you before complying, so that you can check it out. Really? Do we really have an obligation? Is this lawful access request valid? And so that's one way to keep control. Another way to keep control is to have reporting requirements, to have your service providers or your affiliates send you, say, every month, the number of lawful access requests that they have received and how they have dealt with them. Another critical point is having guidelines for your staff about when are we going to challenge a lawful access request and when are we going to comply. And it can be a very strategic decision. Going back to Microsoft that you just described, Todd, the efforts they went into challenging, to me, that was immensely strategic. First of all, they're honoring the trust of their clients. And secondly, they showed to be a data privacy organization that respectful of data privacy. So we really need, an organization needs to say, okay, this is when we're going to challenge, this is when we're going to comply, and develop the expertise to analyze lawful access requests to then make those strategic decisions. Okay, well, is this lawful? Does this authority have the right to compel? So you need to have either this internal capacity or outside counsel that can provide it. And finally, to keep legal control is to transfer as little data as possible, right? You just make sure that you limit access. Then, of course, there are all of the privacy engineering methods, minimization of data transfer. So just transfer. Let's say you outsource the pay administration of your staff. Make sure you transfer the minimal data that is necessary for that. If possible, if in that context it makes sense, perhaps you could just transfer pseudonymized data or anonymized from the point of view of the service provider, but pseudonymized from your point of view because you can reattach it as needed. Make sure you have access privilege controls so that you can check whether there's any derogation to the access you have granted. Automated deletion is a way to make sure they don't keep data for longer than you have in your data schedule, retention schedules. Data segregation is a point that you've made, Todd, earlier on, but it's also part of governance. And of course, technological safeguards against direct state access. We have to say it, there are states that actually will target directly. We're not talking about a lawful access request. We're talking about hacking, state hacking. And so organizations have to keep that in mind as well. So those are governance measures that really bring us to preserve some form of risk management of the reality of extraterritorial reach.
Oh, you're on mute, Gianji. And if I can
Yeah.
use this moment just for a
Yes.
second, we've stacked up a bunch of questions that are sort of relevant to this, and I thought I'd address them real quickly as we move on to our strategies. So we have a great question about space data centers, about storing and computing in orbit, and how do we see data residency holding up? I actually, in many ways, in many jurisdictions, it will almost be irrelevant. And because the idea is, at least from the US and I would assume Canada, it's more a question of whether you can access it. So having your data in space wouldn't make it necessarily any less accessible to you. In fact, it might make it even more accessible. And when it comes to Europe, and I'm sure that Janji could correct me if I'm wrong, but the question would be, you'd lose any possibility to argue that it's an equivalent protective state because you couldn't focus on any jurisdiction. So you'd still have to do your transfer impact assessment, and you still have to justify that using the space company is a valid way to protect the information of European residents. But it gets right into the next question that we got. And it says, how can you limit US jurisdiction when US companies like Amazon and Microsoft are the main suppliers of cloud services? I actually think it's a great question, but I actually think it's not looking at the full issue necessarily, because I think it's less important whether it's a US company or a European or some other company, because a US company and many of the companies that you've mentioned have set up their services so that the information is encrypted and they don't have access to it. So that even if the US has jurisdiction over the company, since they can't access your information, they couldn't turn it over if they wanted to. That's why your settings and your terms matter. And the same thing, sort of the opposite thing is true as well. You could have a European company, but they market to the US. And if they have access to your information and the US asks for that information, they'd have to turn it over, because they have access to information and they fall under the US jurisdiction. So I would urge you to look into the details. The details matter. It's not just the location in which the company was founded. And then I'll follow up real quickly about the security and handling of I think, Gilbert, I saw your great question. I think that you have to make sure that both the contract and the technology align with respect to the access question. You want to make sure that the company you're giving the information to, from a technological standpoint and a contractual standpoint, don't have access to your data. And then the last one I'm catching up with is about vendors not providing you with information over these very important details. It's time to look for a new vendor. I'll just say it flatly, because if a vendor can't answer the questions you're asking, then you can't document your reasoning for dealing with the data. And you certainly can't have any confidence that they wouldn't be turning over your data if they got an order. And I'll stop there. I think I've caught up with most of them. There are a few more, but we can catch up with those later.
Thanks, Todd. And by the way, I were not seeing these questions, so really, really helpful. And by the way, about the last point you made, certain European legislation actually derive actually from the fact that certain vendors were not providing answers. So they had to, there's been a big lobbying for obliging certain operators to provide certain information, and actually certain provisions of the GDPR are actually strictly related to that as well. But so just to try to wrap up and provide a summary, and you need to set a strategy. I took some notes. You need to do your proper risk assessment. There's no customized or boilerplate measures any longer that would work for all data transfers, and actually it would protect you actually from all accesses. But Chantal, if you can help us, and we move to the next slide, we've got few questions to say what to do actually when you're subject to an authority's jurisdiction. Could you please help us? We don't have a lot of time, but we've got, I'm sure you can provide the right answer and guide us through that.
Well, I will try. I mean, I'm sharing what I think are the questions that an organization who understands its duty to protect the data of its customers includes that of protecting it against lawful access requests. If they are constitutionally valid, if they are legitimate, of course you comply. But you must, first of all, determine whether they are lawful, whether they are emanating from an organization that has the lawful authority to make it. So, first of all, let's take the OVH group situation. Who is subject to the issuing authority's jurisdiction? Well, in this case, both the affiliate was in the country issuing the production order. Well, that makes it compellable under that law. What process statutory authority and request category apply? Well, in this case, it was a production order under the criminal code. So we have, again, some definition around the lawfulness of the request. Who has possession, custody, access, or control? And this is where we go back to Todd's point that it's not just about where data is located. And one of the questions, in fact, was talking about how we've shifted from data residency to data sovereignty. Yes, exactly. So we need to look at, okay, how do our systems work? And does the affiliate, for example, who is subject to the issuing authority's jurisdiction, have access, control to the data that is sought? And then you have to look at the local laws. For example, in the case of OVH Group, OVH France argued that a blocking law in France prevented it from providing the data. The court dismissed the argument because that law in France was really about data that, if it was disclosed to a foreign entity, could put in danger the economic interest and national security of France. It didn't really apply here. But you do need to ask yourself the question. It is the right question. And then finally, which recognition, enforcement, or cooperation route is available? That's when the example, let's say, of Microsoft, where Microsoft said, U.S. Department of Justice, you have the Mutual Legal Assistance Treaty vehicle, use that. So that, I would say, is the fifth question to ask yourself when you're dealing with such a request.
Thank you. Thank you. Thank you very much. And Todd, I can't see you. Yeah, and now I can see you again. So Todd, what about when a request arrives? What shall we do?
Yeah, so I think this is another instance where it's really important to having prepared in advance and having everything ready to go. So the first thing you need to do is you need to make sure that you're not deleting or destroying information that's been requested, and that you're also not producing it immediately until you've had a second to take a look at, what the request is, what your proper response should be pursuant to your policy. So don't destroy, don't hide, don't produce. Sit back and do your analysis. Secondly, you want to make sure that the authority who is requesting the information is actually the authority that they claim they are. Because we've seen data breaches where threat actors can come in with supposedly a law enforcement request, and they're not actually who they claim they are. So if you're too eager to comply with a request, you could actually produce very sensitive personal information to a wrong party. And, an interesting point is, arguably, even if it is a real authority, but they didn't follow their legal process, if you didn't check to verify that they follow the right legal process, in many ways, that could still be considered a breach on your part because you produced data when you shouldn't have, when the request that you honored actually wasn't a lawful request to begin with. So regardless of whether you hold yourself out as being a pro-government, sort of a pro-anti-terrorism company, or whether you're a privacy-first company, and those are real marketing choices. The privacy-first companies, like, a great example is Apple. Apple will fight the request for everything because they say, we market on privacy, and so we're going to challenge every request that we get to make sure that it's valid. So you're going to want to look at the authority, the process. Did they serve you correctly? Was the service good? Is the scope appropriate? Is this an overbroad request for what they claim that they're getting? And what's the deadline like? So then you're going to want to look at, okay, let's look at the information that's been requested. Who actually holds it? Do we hold it? Does one of these other affiliates over which we have no control, do they hold it? And, thinking about who this affects, what the privilege is, and how this fits into your response. Next, you're going to want to look at what are the jurisdictions that are at play here? Is it the U.S. and Europe? Is it U.S. Canada or U.S. and wherever? And what are the local legal restrictions? And do we have to provide notices? Whether that's pursuant to a statutory requirement, or maybe you have contractual requirements. So maybe you entered into an agreement with your customer that says, all right, I'm going to let you know if I get a request. To the extent I'm permitted by law, I'll let you know. So then you'd need to honor your contractual obligations and make a notice, but you'd also probably have to take a look and see, is this legal request confidential? Because some requests are pursuant to investigations of terrorism or crime, and there's a requirement in the request that you can't disclose that you've gotten it. And then, of course, you're going to want to look at your challenge routes and see whether it's appropriate to challenge. And then, finally, you're going to narrow, minimize, secure, and document your response. Because even if you've gone through all these steps, if you disclose the information in a way that's overly broad or that's insecure, it could get hacked or taken over, the next day. So, and then, that brings us to what you should do on Monday. So, as we've been talking about, or I've been going on far too much about getting ready in advance, what you really should think about now is map your data, understand all the entities in your organization, your vendors, understand what types of practical access and control they have over the data, reassess any high-risk transfers, really all of your transfers, and to really take into account your foreign government access. Look at your contractual provisions with everybody. Take a look at whether people have to give you notice unless they're legally prohibited from doing so. Take a look at what they have to do to challenge requests. So look at all of your contract provisions, both with your third parties to whom you owe a duty to protect their data, and also all the third parties that may owe you a duty, and make sure that your contracts line up with your expectations and your strategy for dealing with data protection. And then you're going to want to test your key segregation, meaning your encryption keys. Who controls your keys? Does the control align with your strategy? And think about how you're going to support, the access and your request, your response workflows. Do you have things set up so that when you get a request, the different entities can collaborate to the extent they're permitted to ensure that you're processing them in a right way? And then finally, you're going to want to track all of these currently pending developments that are happening around the world. And with that, I'll turn it back over to Gianji.
Thank you very much. This is extremely interesting, and actually, some of the measures, actually, most of the measures, actually, equivalent to what we would advise here on the other side of the Atlantic. So it's actually great to set up a global approach. And one thing that is actually very important that you've just mentioned is extremely interesting is actually, first of all, set up to your providers an obligation to challenge the request. So it's explicitly provide is actually there are certain, in Europe, we do devise certain specific clauses for US providers, for instance, taking into account the US provisions. And you know that, Todd, because you helped us on that, but also minimize the processing on data and be aware of the fact that actually you're responding to a request may itself be a breach of local laws and actually even a data protection breach. So of the personal data you're actually disclosing. So it's don't rush necessarily. This is really not a good idea. And thanks really, Todd, and thanks, Chantal. I don't know whether you want to add anything. We started with you. I would like to leave you actually the last word as to what to do on Monday beside having your coffee and setting up these actions. What I would add is, first of all, read the article that has been written by Chantal and Todd. Here you have the QR code to read that. And obviously we do provide more in our blogs, in our resources, and you can definitely find them. But Chantal, what would be your last word?
Well, I would really think we need to remember what I said a moment ago, that data sovereignty is more an aspirational concept than a real one. And therefore, we need to manage legal risk very closely.
Thank you very much. And by the way, I know I shouldn't do that, but I received amongst the comments, one that you are fantastic, very clear and insightful, Todd and Chantal. So thank you. And actually, I do agree with this comment. I wasn't the one writing it, and it wasn't from someone from Dentons. So that's very good. So is there any still question you want to answer? We may have a few seconds.
Yeah.
There's one about the Patriot.
Yeah. I see there's a question about the Patriot Act. And again, what I think that's really important in the US is Congress is fighting with the administration right now. And they're fighting over who is going to be get certain positions with respect to national security. And so technically speaking, Section 702 has not been reapproved. So that doesn't have anything to do with retrospective approvals for surveillance. It has to do with prospective. Do I think this will get resolved eventually? Yes, I do. But again, when you look at the legal framework around this, it's really easy for people to misunderstand that these provisions make it easier for people to surveil. And when in reality, a lot of the provisions have certain protections in there around the government can't do mass surveillance of US citizens and of US things. So, one of the things I've heard clients talk about is maybe they should segregate all their data, the non-US from the US. I would point out that would make the non-US actually easier to surveil by the US government than it would be if you had the information combined. So I'm not giving legal advice on this webinar, but I just want you to step back and think about the role of these statutes and sort of the impact can sometimes be counterintuitive to what they seem on the surface.
Thank you very much. I think by the way, I fully agree with it. Like when our clients come to us, we don't have an issue about data transfers and data access because all our servers are in Europe. And I said, okay, it's not, and our provider servers are in Europe. I mean, that's not enough, as we have gathered from this very insightful webinar. And most of all, I know we've run out of time. Thanks for your questions. We'll obviously, if you have any more questions, please send them to us. We'll be happy to respond. Super thank you to all of you that have attended, really a lot of you. And thanks, Chantal. Thanks, Todd. It's always a pleasure talking to you, and it's always a pleasure seeing you. So we'll obviously follow up because there will be a lot more on this topic. Thank you very much.